Hey guys, welcome back to today's video. This one is absolutely wild. You're about to watch a self-proclaimed sovereign citizen step into the courtroom thinking he knows the law better than anyone else, but things don't go the way he expects. As he confidently throws around arguments that make no legal sense, the judge stays calm, sharp, and completely in control, shutting him down at every turn. It's one of those moments where confidence meets reality and reality wins. Trust me, you don't want to miss how this unfolds.
25T 5884. Entries from the people.
Ken G for the people, Your Honor.
And with that, good morning, or rather good afternoon now for the defense. State your first and last name for the record.
Robert Richards.
And with that, go ahead and have a seat. We're going to go ahead and do housekeeping. So we're here for motions, and there's no resolution in this case?
No, Your Honor.
All right. And so with that, did you receive Mr. Richards' motion to dismiss the charges in this matter?
Yes, Your Honor.
And Mr. Richards, would you like to supplement the record by any oral arguments?
No, ma'am.
All right. And so for the people?
Your Honor, we would respectfully ask the court to deny this motion to dismiss. There is a factual basis for the charges as well as an unwillingness by Mr. Richards to come to a resolution in this case. So I believe that going to trial is appropriate resolution.
And so I just want to make sure I clearly heard you. You asked me to deny the motion because he's unwilling to resolve the matter?
We have not come to a resolution in this case.
Do you think that's a legal basis in which the court could do that?
And additionally, I believe there are enough facts to support the charges, Your Honor. And I believe that the people can prove this case with a reasonable certainty at trial.
And so as to Mr. Richards' motion, did you actually pull the cases he has cited?
I apologize, Your Honor.
As to Mr. Richards' motion, did you ever pull the cases that he has cited?
Yes, Your Honor. And the people would argue that these cases are not pertinent to these charges.
Can you tell me why?
Under Flournoy v. First National Bank, Mr. Richards quoted, "If the state converts a right into a privilege, the citizen can ignore the license and..."
And this would be under which case?
He quotes Flournoy v. First National Bank of Shreveport. It's 197, California.
And before you go any further, because I did pull these cases, one of them, the cite's incorrect. All right, you may continue as to Flournoy versus First National Bank of Shreveport.
He quotes that case saying, "If the state converts a right into a privilege, the citizen can ignore the license and fee and engage in the right with immunity." I apologize, Your Honor. I believe that's Shuttlesworth v. City of Birmingham, 373 U.S. at 268.
Okay, because that's the case that I could not find.
I also could not find that case, Your Honor.
But you were able to locate it?
I was not able to locate that case, Your Honor.
I'm sorry?
I was not able to locate that case, Your Honor.
Okay, that's the incorrect cite. And so as to the others?
When you choose to represent yourself in court, you might get a bit of flexibility, but there's still a basic standard you have to meet, and that starts with getting your legal citations right. Take Shuttlesworth versus Birmingham, for example. It's a legitimate and historically significant case that played a major role in the civil rights movement in the United States. But throwing it around to justify unrelated arguments doesn't make your position stronger. It does the opposite. It becomes painfully obvious when someone tries to stretch a serious civil rights ruling into something it was never meant to address, like claiming it somehow supports the idea that requiring a driver's license is a violation of personal freedom. That's not legal reasoning. That's misunderstanding the law entirely.
As to Murdoch v. Pennsylvania, 319 U.S. 105, no state shall convert a liberty into a license. So I believe that case was decided in 1943 about wares and merchandise. I don't believe that pertains to a driver's license, and as the facts in this case do, Your Honor.
Okay. So with that, Mr. Richards, would you like to respond to her arguments to the court as to why I should not grant your motion to dismiss based on the cases you have cited?
Well, we can start with Article 6, Clause 2.
Of which Constitution?
The United States Constitution.
Let me go ahead.
All persons born and naturalized in the United States are subject to jurisdiction of, therefore of, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of liberty or property without due process of law, nor deny any person within its jurisdiction equal protections under the law. Now I'd like to cite the definition of liberty: the freedom and exemption from extraneous control, the power of the will and its moral freedom to follow the dictates of its unrestricted choice and to direct the external acts of the individual without restraint, coercion, or control from others. I apologize. The first amendment I read was Amendment 14, Section 1. Article 6, Clause 2, all debts, contracts, and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. The Constitution, the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or the laws of any state contrary to the contrary withstanding. The senators and representatives before mentioned and the members of the several states legislatures and all executive and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. The United States Code is the supreme law of the land. All states are required and bound by it. And the USC recognizes no law for a driver's license, for inspection, for insurance, or for registration. And the only law that they do have on the books is regarding registration for commercial vehicles. The word driver is a commercial term, which means that you're using the road for a commercial purpose or for a hire purpose. I have stated since I met with the officer who initially pulled me over that I am a private traveler.
Any additional arguments you'd like to make to the court?
I mean, I can cite the right to travel, which is Second American Jurisprudence, Constitutional Law, Section 329, page 1135, which states personal liberty largely consists of the right of locomotion to go where and when one pleases, only so far restrained as the rights of others may make it necessary for the welfare of all other citizens. The right of the citizen to travel upon the public highways and to transport his property thereon by horse-drawn carriage, wagon, or automobile is not merely a privilege which may be permitted or prohibited at will, but a common right which he has under the right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee, one may therefore, under normal conditions, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected not only in person but in safe conduct. And personal liberty consists of the power of locomotion to change situations or removing one's person to whatever place one's inclination may direct without imprisonment or restraint unless by due process of law.
Lately, there's been a citation making the rounds online, often used to support so-called right to travel arguments, but it doesn't hold up under scrutiny. The claim usually points to a supposed 2021 Supreme Court case involving someone from South Carolina, often named as John Dalen, but there's no recognized decision like that from the Supreme Court of the United States. What's actually being referenced, American Jurisprudence 2D Constitutional Law Section 329, page 1135, isn't a court ruling at all. It's a legal encyclopedia entry, and in this context, just reflects a claim made in a filing, not an authoritative judgment. In other words, it's a perfect example of how something can sound official and convincing, yet fall apart the moment you check what it really is.
Any additional record before the court rules?
I can read the USC that regards the requirement for registration, since we have a registration here, but I don't feel like that's really necessary at this point, do you?
Well, that'll be up to you. I'm giving you your time before the court.
49 USC 31704, vehicle registration. After September 30th, 1996, a state that is not participating in the International Registration Plan may not establish, maintain, or enforce a commercial motor vehicle registration law, regulation, or agreement that limits the operation in the United States of commercial motor vehicle. This is not registered under the state law if the vehicle is registered under state law participating in the plan. And that's USC 4931, subsection 31704.
All right. And thank you for that. And with that, the court will now rule as follows in this case. As to Mr. Richards' motion to dismiss, he has cited as his legal authority Murdoch versus Pennsylvania, which can be found at 319 U.S. 105. It's a United States Supreme Court case from 1943. And then we have Flournoy versus National Bank of Shreveport, which can be found at 3 Southern 2nd 244. That is a Supreme Court of Louisiana case from 1941. Both are still good case law. The court did try to find this Shuttlesworth versus City of Birmingham. The cite is 373. I also looked at 375 U.S. 260. That case does not exist under that cite. Okay. And as to each of these cases, we are here on this driving under restraint and an expired license plate charges. The first is a Class A traffic infraction. The second is a Class B traffic infraction, ineligible for a jury trial, but a court trial. And as to Flournoy versus the First National Bank of Shreveport, the actual issue in that case is that they did challenge, and that would be Flournoy challenged a statute that was limiting in-value bank shares for taxation. The court found that that was unconstitutional. It has no bearing on a driving under restraint or a license plate being expired. And then in Murdoch versus Commonwealth of Pennsylvania, what was happening there is that the city of Jeannette, and it was an ordinance by the city of Jeannette in Pennsylvania, was prohibiting the sale of goods, wares, and merchandise of any kind within the city by canvassing for or soliciting without a license. And the United States Supreme Court found that that was in violation of the Constitution, the United States Constitution, freedom of speech that is guaranteed by that First Amendment, because it was preventing people that had religious beliefs or were on the streets just preaching the gospel from distributing religious literature and then having personal visitations with individuals as they walk by. And they found that that requirement prohibiting any sale of goods, ware, or merchandise of any kind without a license was in violation of the First Amendment. And so as to all that has been cited by Mr. Richards, I appreciate it, but we do have laws here in the state of Colorado that do require you to have a driver's license and that privilege, and also have your vehicle license. And so as your motion to dismiss the charges in this case, that will be denied.
I'm still waiting to see a case where a so-called sovereign citizen actually wins in court based on those arguments alone, but that moment hasn't come. Until it does, all you really see are the same claims being repeated, only to fall apart under real legal scrutiny. Courts consistently rely on established law and precedent, not personal interpretations that don't hold up, so these arguments tend to go nowhere fast. And honestly, watching that clash between absolute confidence and actual legal reality can be as telling as it is frustrating.
So at this point, Mr. Richards, we're going to go ahead and go to what is called housekeeping. So have you gotten down to the district attorney's office and received your discovery in this case? All right, you will need to have your discovery because the people are indicated they have 2 audio files and 3 video files for a total of 5 media files that they may be using in a trial. You will need to be able to review those, because I'm going to set some deadlines, because I need the parties to confer about what will be coming in and what will not be coming in. And it'll be extremely beneficial if you know exactly what that is. And so during housekeeping, what I do is I go back to the date and time that a case was filed with the court. And I review all motions or notices that could potentially affect trial in this matter. And since the not guilty plea was entered and the JASP order went into effect, the people filed one notice of endorsement of witnesses on just September 12th of this year. Did you receive a copy of that? And could you approach? Here's all I'm going to give you a hand delivered to your copy. These are all the people that they possibly or potentially could call, and that's for you. You can keep that. That's yours.
Wow.
Oh, that's who they're going to call or potentially call. That's their potential witness list.
So the officers that were there on scene?
Yes.
There were
whoever.
3 officers, not 4.
And they're saying there's 4. So,
I saw 3.
and so that's who they're intending. They could potentially, I'll make it tell you that they will actually call those 4 officers or whoever the 4 witnesses are listed, because I didn't look at it that closely. But that's who they're intending or potentially could use as witnesses in this case. If you want to know how those individuals are related to this case, that's where the discovery comes in, because there should be reports from those individuals or some type of statements or some type of mention of those individuals in somebody else's reports. That discovery will tell you exactly who those people are, hopefully, and also we have all these audio and video files. So with that, would you like to go down and get your discovery? In this case, it's free.
Yeah.
All right. So could you give them your address to your office? And you need to just go to, I think the fastest way is to go down there. Is it the fastest way to go down there and get it? Or does he do it online or?
To request it online first, and we have to process it for him to be able to.
So what happens if he goes down to your office? Can you request it as he's standing in your lobby?
I believe Central Services needs some, I believe they said it's 7 business days at least to process discovery.
I know, but that's for the processing time, but the actual request. Can a person go to your office and request a discovery in person?
I'm not sure with that method. I think it's usually online, but online should be fairly easy too.
And I'm going to assume there may be a mechanism, because not everybody has access to a computer.
Yes, Your Honor.
So would you, if you'd like to, go down to the office and see what they have to say about how you can request that. Give them your address. You'll have to go directly to their district attorney's office.
Going to ignore my right to liberty and my right to locomotion.
They're not ignoring some supposed constitutional right to locomotion, because no such right is explicitly granted in the United States Constitution in the way it's often claimed. What's actually happening is much simpler. The law recognizes the government's authority to regulate how people operate motor vehicles on public roads. Driving isn't treated as an unrestricted personal right. It's a regulated activity that comes with requirements like obtaining a valid driver's license. So when courts reject these arguments, they're not denying freedom, they're rejecting the mistaken belief that anyone can legally operate a car without meeting basic legal standards.
No, I'm just telling you down to Colorado law that these are valid charges, that the state of Colorado has the authority to actually enact these types of statutes.
Okay.
Okay. And so with that, for the people, did you file any additional motions or notices that the court is not aware of?
No, Your Honor.
And there were none other than the motion to dismiss filed by you, Mr. Richards, is that correct?
Yep.
Okay. So again, people have 2 audio files and 3 video files, for a total of 5 media files. And with that, the court will now issue the following orders. As to those 5 media files, the parties are to conclude their conferral as to which portions or which portions will or will not be used of those 5 media files by this next deadline. Also, if there's any additional witness endorsements or initial witness endorsements, they must be filed by this deadline. And if any party wishes to use an expert, that expert must be disclosed by that same deadline, along with the CV for the expert. And Mr. Richards, you know what a CV is, correct?
No.
Okay, a CV is the equivalent of a resume for an expert. It actually stands for curriculum vitae, CV, curriculum vitae. And all this is basically a resume for the expert to say why they're expert, what type of training experience, classes they've attended, those that they've actually taught at themselves, recognitions within that industry. And also pursuant to Rule 16, I'm going to order that a summary of the expert be provided. In other words, tell the opposing party what the expert will be testifying to. So again, the parties are to confer as to these 5 media files of what will and will not be used by this deadline, conclude that conferral. Also, any additional or initial witness endorsements, if you're going to include anyone as an expert, you must designate at that point in time in writing that the person is going to be an expert. Tender over to the opposing party the CV for that expert, and also a summary under Rule 16 of what that expert will be testifying to. That must be done by Friday, October 3rd. That if there are any objections to any redactions to that media or lack thereof, that objection must be in writing and it must be supported by a legal basis.
So if I just want to pay the fines now, you're obviously not going to side with me in this. So if I just want to pay the fines and walk away from this.
I'm not either siding with or for against anyone. I just follow the laws here in the state of Colorado.
My right to liberty is invalid. So if I just want to pay the fines and walk away from this, what?
No, you have rights and you have liberties, but also here in the state of Colorado, these are valid charges.
Not in the state of Colorado. I'm a man standing on land. I am not a dead entity inside of a state.
Okay. Would you like to enter into a plea agreement then with the people?
What are we looking at for fines?
Oh, I can do. Can we pass, Your Honor, while
You may.
discussing?
So after all that, they step aside briefly to talk about possible fines and fees, which is honestly a bit ironic, considering it only took pointing out that his citations were completely off for him to start backing away from his own argument. What began as confident posturing quickly unraveled, and the whole sovereign stance lost steam almost instantly. That said, nothing was finalized in that moment. The two sides didn't reach any agreement, and the judge ultimately decided to push the case forward, rescheduling it for the following month.
So this October 3rd, do I need to worry about that in this particular instance?
You still would, if you would like to see
So I
what
need
the
to-
discovery is and if you want to object to anything. So there's some additional deadlines. And so we are back on the record on Robert Richards, case number 25T5884. He is present before the court, and so is Ms. G for the people. And so if there are any objections to any redactions or lack thereof of those media files, in other words, people are going to use something that you don't think they should be able to use, or they're not going to use something that you believe that should be used, you must state that in writing, and you must support it by a legal basis. In other words, you just can't say I object. I have to know why you're objecting under the law. And you must tender over to the court the media in question by that next Friday, which would be October 10th. Now, failure to, even though you may have submitted a written objection that's supported by a legal basis, if I do not also receive the media in question by that next Friday, October 10th, then the court will deem the objection to be abandoned. And the reason why is this: I don't have access to their discovery. And so I don't have the media files. I have to be able to have the media file to review it, to be able to rule on it. Now, within that same written objection, the opposing party, you may respond to that objection with your own legal basis. But if you fail to respond, the court could deem your refusal or failure to respond as a confession of that objection. And I could grant that objection as written. But irrespective of if there is a response or not, if a written objection is filed supported by a legal basis and the objecting party has tendered over to the court the media in question by that Friday, October 10th, I will issue a written ruling on the weekend of October 18th. And so with that, because there were no testimonial motions, all motions and notices have been addressed. JASP order is still in effect. The parties, if they so choose, you may plead out at any point in time. And so with that, anything further for the people before I order Mr. Richards back here for the trial?
Nothing further, Your Honor.
And Mr. Richards, anything further for you before I order you back? And so I do order you to be back here, and we will see you back here on October 22nd. That will be a Wednesday, and that'll be at 8:15 a.m. Again, Wednesday, October 22nd at 8:15 a.m.
All right, guys, that's where we're wrapping up today's video. He did have another court date scheduled for Wednesday, but his case wasn't heard, so there's no real update just yet. That said, if he decides not to take a plea deal, there's a very good chance we'll get to see this right to travel argument play out fully in court, and you already know we'll be covering every moment right here on the channel. So if you enjoyed this breakdown and want to stay updated on what happens next, make sure you stick around. You won't want to miss how this unfolds.